You got some people who call you whose life is on the line. And sometimes that's the hardest part of it. And sometimes that's the best part of it. You have a very close relationship with your client. You have it's a very consequential area of law with very little pretense.
Welcome back, everyone, to the From Crisis to Justice podcast. I'm your host, Parag Amin, and I'm joined by special guest, RJ Dreiling. He is a criminal defense lawyer and a former senior prosecutor for Los Angeles County. He has handled multiple high-profile cases involving murder, fraud, conspiracy, and kidnapping. He's helped everyone from Hollywood actors to CEOs. And throughout his career, he's focused exclusively on criminal law. So, RJ, thank you so much for joining today.
Yeah, thank you for having me on. I'm looking forward to the conversation.
Yeah, absolutely. So, can you tell us a little bit about why you chose criminal law as your path to pursue?
Yeah, so I think I wrote my law school entrance exam. There was a big grocery strike here in Southern California in like 2003 when I was working at Vaughn's. And I remember I wrote my entrance exam about wanting to get into employment law. And something happened when I got into law school. I was in a trial advocacy class, and there was an opening for a clerk at the DA's office in Torrance. And I figured, hey, maybe I'll go do an interview and check it out. And I remember I walked into the office, and it was, it was a little dingy. There were 2 or 3 people to an office, and I remember, those inspirational posters you see sometimes that say have like an eagle flying over the mountains and says courage. Like clearly someone had just kind of taken out of their garage and thrown up on the walls. But there was a kind of I just kind of fell in love with it when I got there. And not just the DA's office itself, but then you go to court and, you're sitting there as a clerk with the DA, and you could tell they have a decent relationship with the public defender, a decent relationship with the judge, and everyone's kind of getting along. That aspect of it really appealed to me. And it was I had worked at a really great employment firm that previous summer and that summer. But it was just the really informal aspect of the work in criminal law, the opportunity to be in court. I mean, for my job now, I'm in court just about every day. The opportunity to be in court, the informal nature of it. And, you get some high consequence cases. You got some people who call you whose life is on the line. And sometimes that's the hardest part of it. And sometimes that's the best part of it. You have a very close relationship with your client. You have it's a very consequential area of law with very little pretense. The discovery process is you talk to the prosecutor, do you have my discovery? It's not a lot of interrogatories and things like that. Very kind of informal and fast paced. And so, when I clerked there at the DA's office, I knew that's what I wanted to do. And I was fortunate enough to, when I graduated, to get a job there. I was there about 15 years and then left about a year and a half ago to start my own private criminal defense practice. So I've been very fortunate. And I think many of us, I think that's the sense with you too, Parag. You seem to have landed in an area that you really enjoy. And I feel very fortunate to have landed in an area of law that I really genuinely enjoy.
That's amazing. I love that. So at what point did you decide that you were going to go from government prosecutor to private criminal defense lawyer with your own firm? Was there a specific moment in time that you decided that, and what was that?
I had always kind of kicked around the idea of having my own practice. I really like the idea of being my own boss. I really like the idea of kind of building something up from the ground up. And, and I said this a moment ago, everyone kind of gets along when you're in criminal law. And I had a lot of respect for a lot of private criminal defense attorneys that seem to really have a good practice going. And I talked to them and they seemed to enjoy it. And I just kind of reached a point in my career. I was fortunate to do a lot of kind of consequential work as a prosecutor. I handled some high profile cases, but I just kind of felt like it was time for me to try something new. Just kind of like how I knew when I walked into the DA's office that was what I wanted to do. About 2 years ago, I just kind of knew it was time for a change. There's definitely an adjustment period for having been in law enforcement for so long, now going and working on the other side. I remember, oh gosh, I think the first client I ever met, he worked at some oil refinery in the South Bay, and he had called in sick one day to work. But the day he had called in sick, the FBI had like raided their entire office and arrested everyone. So, but for the fact he had called in sick, he probably would have been in custody. So he came in for an interview. This is, I think, one of the first ones people I'd talked to. And he walks in, he says, "How are you doing?" And I say, "Good." And then my natural response is to say, when someone asks you how you're doing, "How are you doing?" And he looks at me like, "How the hell do you think I'm doing?" So it's definitely a bit of an adjustment, right? I've learned to take the "how are you doing" out of my initial introduction. And it is a bit of an adjustment. It took about a couple months getting used to being on the other side of things. But at the end of the day, the legal work is very similar to what I did. You can kind of pick that up very quickly. And, it's been really rewarding. Like I said, I've been fortunate to have had 2 jobs I loved in my life, and I'm really enjoying what I'm doing now.
That's awesome. What kind of things have you had to navigate as a first-time business owner?
Well, you know how it goes. The nice thing with a government job, you have that steady paycheck, and you basically have to commit a high-level felony to get fired from your job. So it's very secure. There's many parts of it that I really liked, but the steady paycheck is very nice, and you kind of take it for granted when you go out on your own. And as you know, when you're building a practice, especially the first year or so, the income just goes up and it goes down. It goes up and it goes down. And that can be a little bit, anxiety provoking, for lack of a better term. And for me, part of what getting used to this particular aspect of it is getting used to the ups and downs, and learning that it's a part of the process. And, one of the most encouraging phone calls I can make when I'm going through a period where maybe the phone isn't ringing as much as it normally does is calling someone else in my field and hearing, they're a little slow too. That "I'm slow too" conversation can help keep you sane. Where our line of work is seasonal. For whatever reason, people get arrested. They're not that interested in hiring an attorney when their kids are out of school. But then when their kids get back into school, we get really busy from like mid-October to about, the beginning of November. And it slows down for the holidays, and then it picks up again. So the seasonal aspect of it is something that was definitely something that was hard to get used to at first. But once you go through enough of those cycles, you kind of learn that the phone's going to ring again. You're going to be okay, and just kind of keep moving forward.
Yeah, and if somebody's thinking about this, somebody listening to this, they're thinking about starting their own law firm or maybe starting their own business, what kinds of tips or advice would you provide to them?
The thing that worked for me, there's a subset of criminal defense attorneys that are former prosecutors, kind of, and we all kind of, talk and kind of hang out. So, when I was thinking about going out on my own, I was fortunate enough to talk a lot of conversations with a lot of really good people. A guy named Joe Marcus in particular, Josh Ritter, Ty Anise, Pat Carey, all really good folks. Sam Amanpour, Sandy Rojas, all really good attorneys who they're very busy, more than happy to take the time to talk to me. So my advice would be, if you're thinking about going out on your own, is make sure you talk with some people who look like they've got the hang of it. And you'll get, they've been through it, they've been through the ups and downs, and they can give you a lot of pointers. The one thing I kept hearing early on when I was thinking about going out on my own for criminal defense was, there's two rules for criminal defense. The first rule is get the money up front, and the second rule is get the money up front. So it's one thing I did not have to learn from that mistake. I talked with a lot of people about it, and it worked out. So, I found people to be very generous with their time when they're talking with someone who's thinking about going and kind of doing the same thing they did, which is going out on your own, investing in yourself, and seeing what you can do.
Yeah. And have you felt like that has been a journey of self-discovery? That's one thing I've heard about entrepreneurship. That's something I felt throughout entrepreneurship is you learn a lot of things about yourself and a lot of things about the world that it feels like I don't know how I would have learned them really any other way.
I mean, yeah, absolutely. Look, you get to know the things that you're comfortable with and the things that you're not comfortable with. And the things that you're not comfortable with in your business are the things you probably should spend the most time doing. It's the stuff that you don't like that you need to work on. And for me personally, the legal work is my favorite part of the job, and being in court and negotiating a case, breaking it down, jockeying with the judge and the prosecutor, picking apart the reports and all that. The thing that is something that I'm learning to appreciate more is the networking and the business aspect of it. So while it's not my favorite thing to do, that's certainly something I need to learn, or I need to continue to grow in. I don't know, there's certain aspects of your personality, Parag, maybe that you've discovered since running your own business that that you might not have found out otherwise.
Yeah, absolutely. I mean, I think a big part of it is learning to understand what you don't know. And because look, there's a split between the things you know you don't know,
Right.
and the things you don't know that you don't know. And spending a lot of time figuring out the things you don't know that you don't know, and being or feeling lost for a little while trying to figure those things out is so critical. Because to your point earlier, it's easy to go back to the things we're already comfortable with and the things we already know. And I think the entrepreneurship journey and the journey towards becoming entrepreneurially mature is that journey of becoming comfortable with discomfort and becoming comfortable not necessarily having all the answers. Because a lot of times that's one thing I found out is the things I knew the answers to, or I knew I could figure out more easily, such as things I had experience with, such as practicing law or being in court, those were the things I gravitated towards because they were comfortable. Those are the things I knew. And if I didn't completely know it, I had enough points of reference that I could figure it out. Whereas to your point earlier regarding networking or how to build a business or how to delegate tasks, those were not things I learned in undergrad, despite having a finance degree. So despite being in the business school and despite going to law school, they don't teach those things. Those are things you got to figure out and learn on your own. And those things are hard because there aren't really guide rails or guardrails to help guide you to figuring that out. That's a journey you got to find and choose to go down on your own. So that's awesome that you're learning that very early on, because it took me a little bit of time to really understand that.
Yeah, that's 100% right. You know, the amount of time we spend on, I mean, everyone who went to law school remembers was it Pearson versus Post, the property case involving the Fox or whatever. That probably has limited application for all of us at law students, but there is, I mean, for me, it was almost non-existent, was the focus on the business aspect of building your own firm or the networking, generally speaking. And it was funny. I remember, I think the most important thing I learned in law school was from a guy who had his own practice, and he was a trust and wills lawyer. And I just remember one day in class, he was talking about clients and how to keep them happy. He said, you know what, if you take 5 minutes on a Saturday and call a client, they'll think you're working 24 hours a day, you know? And that's, you know, the kind of practical application that you don't get in law school that you kind of have to learn. But there's value, obviously, in going, like you said, going through the struggle and learning to know what you don't know and making your way through it and building a practice, you know. And it's to your point, it's almost like the challenging part of it is what makes it worthwhile. You know, if this were easy, then everyone would do it, you know. So you kind of keep pushing along, you know. I think that's a great point.
Yeah, and I think each time you're proud of who you come out being. Each challenge, each struggle, every moment of crisis that you successfully navigate through,
Yeah.
You're prouder of yourself having come through it, and you're stronger.
Yeah.
Sometimes it's just that navigation process can take longer than others.
Yeah, 100%. You know, we all have clients that we love, and we all have clients that are more challenging, you know, and we all have situations that we don't anticipate ever having to go through that you end up going through. And, you know, I like your point is that going through these difficult situations kind of makes you stronger and makes you a better, not just a better business person, but a better lawyer, you know? So it's important to kind of keep pushing through those situations and having faith in yourself and getting through it, you know?
Yeah. And speaking of navigating difficult or challenging situations, let's talk a little bit about criminal defense and some of the misconceptions maybe or myths that you've heard about
Sure.
criminal defense law, or maybe police or just the prosecution system in general? Do any myths come to mind that you want to bust right now, RJ?
The question I get very frequently is, the officers never read me my Miranda rights, right? That's usually the first thing. If that happens, that's usually one of the first things someone brings up to me during a consultation. And I think the thought is that if they don't do that, your case gets dismissed. So the way Miranda works is that if officers, after you're arrested, so if a police officer pulls you over for a traffic violation, they don't have to read you your Miranda rights. They can ask you some limited questions. But if you're back at the police station and you're in handcuffs and they sit down and they say, where were you back on this date, or why was this such and such in your car? They have to read your Miranda rights if they want to get a statement from you. Now, if they do it, let's say they completely blow it and they ask you some questions after your arrest and you confess or whatever, that statement doesn't come in, but it doesn't mean your case gets dismissed. It just applies as to they call it post-custodial statements. So that's a big misconception. I will say that there's always a lot of questions about DUIs and the way to handle that, because it's probably it is the more common offense that we see in criminal defense. And the vast majority of people you deal with in DUI, they've never been arrested before. They're always kind of second guessing how they should have handled it. So a couple things just to be mindful of. If anyone's listening finds himself in a situation, the field sobriety tests, which are, touch your finger to your nose, close your eyes, count to 30, things like that, are totally voluntary. You don't have to do them. There's two separate breath tests they can give you. They can give you one out in the field. It's called a PAS, a preliminary alcohol screening device, a very small device. You don't have to take that one if you don't want to. So it's up to you. Now, however, if they do place you under arrest and they take you to police station, you are legally required to either give a breath or a blood sample. So question comes very frequently, what's better to do, the breath or the blood? Generally speaking, the blood is going to be more accurate than the breath. And the nice thing about getting a blood sample is two things. The first thing is that they have to leave enough blood that it can be retested. So if you hire a good lawyer, if you're on the border, sometimes 0.08, 0.09, or whatever the case may be, we can retest that sample and see where we land. And that's a big advantage in a case like that. And there's also the fact that sometimes it can take a little bit longer to get a blood draw. The breathalyzer, they bring you to the station, they sit you down, you're in the machine, you blow twice, it's done. Sometimes they can take a little bit longer for them to get everything they need in order for blood samples. So if you're kind of, potentially teetering on the edge, it gives you a little bit of time to get a little bit more out of your system. So generally speaking, blood is better than breath. And just, the officers may posit like you have to do these tests. You don't have to do the tests as far as the field sobriety tests or the breathalyzer or the PAS in the field. Those very common questions, I will say that one of the best ways that we can kind of attack a case is usually whether or not the officers have probable cause to stop someone. So officers can't just pull people over and check them to see if they've been drinking or driving. They have to have a good reason for doing it. So like a traffic violation or something like that will give them a good reason. A DUI checkpoint. But if they just pulled you over and they do a whole DUI investigation and they didn't pull you over for good reason, we can get the whole case kicked. So in these situations, it's important to get a good lawyer, because it could be the difference between, people have licenses and stuff like that. They have professional licenses. A DUI can be a big deal. So it's important to get a lawyer who really knows what they're doing. And generally speaking, it's a good idea to get a lawyer in the area that you're in. They'll know the judge, they'll know the prosecutor. They kind of know what the prosecutor will respond to, what the judge will respond to get you the best result that we can. So it's very, in terms of that aspect of the job, it's very kind of local, if that makes sense, Parag. I don't know if that's been your experience with employment and personal injury, but it helps to hire someone who kind of knows the landscape in the area.
100%. It's always nice when you've got somebody who knows how to navigate, has the home court advantage, if you will, of knowing the people who are going to be there, knowing the system, and has some level of comfort with the people who are handling the system. Let me ask you, when it comes to the breathalyzer, I've heard mixed things. And by the way, to be very clear, neither you nor I are encouraging anybody to drink or drive.
That's true.
It is dangerous. People get hurt. People get killed every day. Would you agree with that, RJ?
I would agree with that, yes.
Okay. So now let's say somebody finds himself in an unfortunate situation where now they're pulled over. They've got red and blue lights. they've had a few drinks coming from a holiday party or whatever, friend's house, bar, whatever. They're not sure if they're over the limit. So at that point, the police officer comes up, asks you to step out of the vehicle. One, when they ask you to step out of the vehicle, do you have to step out of the vehicle?
So, good question. So, if the officer the officer can only ask you to step out of the car if they have probable cause. Now, that's a question that needs to be resolved later. I would not recommend challenging the officer at that point whether or not they have probable cause. You never want to get into a standoff with someone with a gun. So if an officer pulls up to you, regardless of whether or not in that particular situation you think they had a good reason to, they can ask you to step out of the car. Now, you don't have to answer any questions. They might ask you for your ID. You have to give them your ID. They might ask you to come a certain place. They might ask you certain background information, like your name, your date of birth, things like that is fine. But you don't have to say how much you drank. You don't have to say where you've been going, where you are, where you're going, what you were doing, or things like that. You can just respectfully tell the officer, hey, listen, I'd rather not answer those questions. And that's up to them. And that's the officer's responsibility. It's their job. Like, you don't have a responsibility to help them do their job. That's up to them. And they know what they're doing, so they can ask you. And it's kind of a judgment call for every situation. If you want to do some tests, they might phrase it like, I'm going to ask you to do some tests. Why don't you come over here and do some tests, right? And you say, hey, respectfully, officer, I'm not going to do those tests. Hey, I've got this little, device here. Just going to ask you, we can just clear you up, you can clear this all up, let you go. And you can just say, hey, respectfully, officer, I'm not going to do that. It's up to you. It's your right. And it's just kind of a judgment call in the situation. Ultimately, at the end of the day, if they make the call that they can smell the alcohol on you, that your eyes are watery, or that your speech is slurred and things like that, if they make the call, they're going to put you under arrest. Go back and then, like we talked about, do the blood test. But you're under no obligation to answer questions about where you were going, what you were doing, how much you had to drink, or any obligation to do any of those tests. It's a total judgment call on your part. It's it's not anything I would say there's a blanket policy as far as the best route you should go. But it's up to you. It's entirely your call. And it's their responsibility to do their job. It's not your responsibility to help them.
So let's say they tell you, from the stories I've heard, there's always some kind of component of pressure of, well, if you don't do this, we're going to impound your vehicle. Or if you do this, like you alluded to, you can just be on your way. Are they allowed to impound or take your vehicle if you refuse the breathalyzer?
So if they suspect you of drinking and driving, they can impound your car. It can be up to 30 days. Usually you can get it out pretty quick. I will say, look, if it's a situation where you're being cooperative, they're more likely to have you call a friend or something like that, or a family member to come pick up the car. So that's a risk you run in a situation like that, is if you're not doing them any favors, they're not going to do you any favors. It's kind of the trade-off. And look, at the end of the day, their goal is to, they're going to want to check to see if you've been drinking and driving. And it's kind of, like I said, it's kind of a judgment call. There's always the urban legend that you keep a bottle of whiskey in the back of your car. And then when they pull you over, you grab the whiskey and you pound it in front of the officer. So they can't prove when the alcohol hit your system. Now, I would not recommend doing that. That's the urban legend. It's a matter of evaluating the moment and doing what you think is appropriate. If you're bored, it's always a good idea to talk with a lawyer. Sometimes they'll give you a court date like 3 or 4 months out. And with the DUI, that DMV suspension or the request to challenge it through the DMV has to be filed within 10 days. So it's always a good idea not to wait, but to get a lawyer as soon as you can. After you've been arrested, after you've been out of custody, talk to them, let them know if you have any professional licenses and things like that, and go from there. So it is the most common by far of the cases that we handle. And like I said, it's always people who are never been arrested before, who have jobs, families, and things like that. And they're always a little kind of unsettled. So you hire a good lawyer. They can walk you through the process. They can take away the uncertainty. They can help you, navigate the whole thing and get you the best result that we can under the circumstances. So
yeah, and so can you talk a little bit about that? So let's break this down a little bit for the people who aren't as familiar with this process. So my understanding is under the vehicle code, there's an A charge, there's a B charge, and then there's a separate DMV hearing. And can you talk a little bit about how that DMV hearing goes and whether you have to be found guilty or plead guilty to driving under the influence for your license to be suspended?
That's a great question. So we call it the A count and the B count for DUIs. And in most DUIs with alcohol, they charge both. It's just an either or. Doesn't carry increased punishment. But the B count's the easy one. You probably all heard 0.08. That's the legal limit in California for how much you can drink or how much alcohol you can have in your system before you're legally guilty of a DUI. I think for the average size male, it's about 4 drinks. For the average size woman, it's about 2.5 drinks over the course of an hour will get you to that level. It used to be, by the way, 0.15, which is like 8 drinks. So if someone got a DUI in the 70s or 80s, they were pretty lit. So that's the B count, is your typical 0.08 blood alcohol level or higher. The A count is reserved, generally speaking. It's just kind of a catch-all. Someone who's driving while impaired, and it can be to prescription, any controlled substance. So it can't be like you're tired or you had too much caffeine. If they think you've had too much of a prescription medication, marijuana, or other drugs, or under certain limited circumstances, if your blood alcohol level is below 0.08, but they believe that your condition was such that you shouldn't be driving, and it affected you in such a way that you shouldn't be driving, they'll charge the A count. So you've got the A count, which is usually drugs and things like that, the B count, which is a 0.08 or above. Now, we have what's unique about DUIs, kind of these 2 tracks of the way the system works. You have the DMV hearing, and you have the criminal case in court. The first thing we deal with is the DMV hearing, and that can be very consequential because we're talking about a license suspension. And that's going to be dependent upon, how high was your blood alcohol level alleged to be, 0.15 or higher. Do you have any priors? How old are you? Things like that play into how long the DMV is going to suspend your license. What happens is when you get a DUI, they take your driver's license, they give you a temporary license, and it says on that temporary license, you have 10 days to contact the DMV if you want to challenge your suspension. So let's say you get a DUI, you get arrested, they take your license, and you just don't do anything at all. Don't contact the DMV, don't contact a lawyer. Your license is going to be suspended after 30 days. At 30 days after your arrest. For a first-time DUI, it's about 4 months. They'll give you certain things you can do so you can avoid having to not be able to drive, but that's generally speaking how it would go. Now, if you hire a lawyer, what you can do is you file some paperwork with the DMV within 10 days of the arrest, notifying the DMV that we want to challenge this person's suspension. Right? So like a piece of paper or fax we send over to the DMV. And then about 3 or 4 weeks after that, the DMV will contact us and we'll set up a hearing. It's called the administrative per se hearing. Now, it is very kangaroo court. The judge in this hearing is the same person as the prosecutor, and it's on the phone. And what they're doing is reading the police reports and making a decision about whether or not the person was driving under the influence. That's the main question. Also, whether the officers had probable cause. But that's it. And there's actually been a lot of litigation in this area. And there was a court case a couple of years ago, I can't recall it off the top of my head, that held this process was not constitutional under the California Constitution. So there's some litigation whether or not they can do this. But the way it works is you have a hearing with your attorney and with you if you want to be present over the phone. And we make certain challenges to the way the police reports are written, whether there was probable cause, whether they had a good reason to pull you over, and whether or not the blood alcohol level was 0.08 or above. Now, certain things we can challenge. If the blood draw for the alcohol was taken more than 3 hours after the arrest, we can get it kicked. If there are certain forms the officers did not fill out properly, we can get it kicked. And what that process is called getting it set aside. So you got this track, right? So you got to deal with the DMV suspension, and then you got to deal with the criminal court issue too. And you can get your license suspended here, and you can also get your license suspended in court too. It's this really kind of arduous process where you can get a 3 or 4 month suspension over here with the DMV and a 3 or 4 month suspension over here on the criminal case too. And here on the criminal case, we're talking about whether the person should get probation, whether they should do community service, an alcohol program, fines and fees and things like that. That's what we're talking about over here on the criminal end. And what we try to do oftentimes, if we can settle both these matters at the same time, we run the suspension together. So you don't have a 4 month suspension with the DMV. You have that done, and then your criminal case settles, and you have another 4-month suspension. So that's the unique thing about the DUIs. You kind of have this 2-track process, one through the DMV and one through the criminal courts. And if you get a good lawyer, sometimes we can do is we can get the videos ahead of time for the DMV hearing and take a look at it, see if the officers actually had a good reason to pull you over. We can take a look at whether they did the field sobriety test properly, checked all the boxes, did the breathalyzer properly, and things like that. And sometimes we can get a good result with the DMV. And then if we beat the DMV case, we go to the prosecutor and we say, we beat the DMV case. What are you guys going to do? And see how it goes. So it's a very kind of unique process for DUIs.
Yeah. And I think it's probably surprising to most people to realize that my understanding is that the DMV hearing officer is neither a lawyer nor a judge, despite acting as both the judge and the prosecutor. Is that right?
That is correct. And all they're doing is reading from a script. They're kind of going through the motions, and they're, I'd say you have to have a very nuanced approach with them. A lot of lawyers will just throw everything they can at them. And what happens is they get a little overwhelmed because they're out of their element, and they'll just overrule everything and then suspend your license. So the way to approach these situations is pick one issue that they can understand and poke them a problem, send them a motion ahead of time before the hearing. Be very nice about it. Don't be too confrontational. Hey, I noticed this issue. I know this portion wasn't signed. I noticed that the blood draw was at this time. The arrest was at this time. And you kind of gently push them in the direction that you want them to go. And that's the best approach, because to your point, they are not a judge. They are not a lawyer. And they're out there just reading a script and just kind of going through the motions. So yeah, it's it can be a very difficult process.
And so I don't want to stay on DUIs too long, but I think it's important to touch upon this as well, because it's such a common thing that comes up. Can you let me back up. And it's such a common thing that comes up because I think, unfortunately, people get caught up in a moment or moments of bad decisions that are being made. Mm-hmm. My personal view on it is it's probably not, most people are probably not doing it maliciously, but it just happens. And, but part of the issue is they don't quite understand the repercussions or the ramifications of how serious this is until it's too late. So can you briefly touch upon a felony DUI? So it's a DUI and they hit somebody or something and somebody gets hurt, and what that means realistically in terms of time, money, and consequences, legal consequences.
Yeah, 100%. So that's a great point you brought up about DUIs. You could be, a 0.35 and almost dead. And, let's say you run a red light, you get pulled over. The consequences for you are still going to be close to the consequences for a standard DUI. Alcohol program, fine, maybe some community service, a longer suspension, but it's not going to be awful. Now, put you at that same blood alcohol level, you hit someone, and God forbid they die or are seriously injured, the consequences escalate astronomically to the point where there's a thing in criminal law called a Watson murder. And basically what that is if the prosecutor looks at your case and thinks that you're driving sufficiently negligently or with undue regard for other people, and you have say you have one prior DUI from 9 years ago, 10 years ago, and something happens and someone's killed, they charge it as a murder case. So it can be very serious. You can go from virtually no consequence to a completely life-changing situation. So there's all different kinds of areas where you can be charged with. If you can have a DUI with injury, which is usually a prison, depending on how bad the injuries are, can be a prison sentence. So jail being local, prison meaning long-term. You can have manslaughter while intoxicated. That also means a prison sentence, usually 6 or 7 years. And then you go all the way up to murder, which is life in prison. So it's a really unique offense in the sense that you can have two virtually identical situations, like I described, where a person's had too much to drink, they roll a stop sign, they get arrested. They're getting a low-level misdemeanor where they roll a stop sign, they don't see someone, and something horrible happens to that person. The consequences shoot through the roof, and it's another, it's funny, you can get any more. There's a thing called diversion, which is if someone's charged with a misdemeanor, you can usually get, if they've never been arrested before and it's a low to mid-level misdemeanor, you can usually get, if you have a good lawyer, get the case kicked without a conviction. Hey, judge, we're going to go do community service. We're going to go do anger management. Let me tell you a little bit about my client and what his situation is here. And the judge will agree, go do this and I'll dismiss your case. The one exception being DUIs. That's kind of like the one last holdout where even if you've never been arrested before, even if you're right on the line, generally speaking, your odds of getting diversion are very low. So it's something that's still, despite how prevalent it is and how it is often the product of, the difference is, what's the difference between 0.081 and 0.079? There's really no difference, like practically speaking. But the law, it's an incredibly different consequence as far as the law is concerned. So it's this unique area where, it's very common, but you get the whole spectrum in terms of what the possibilities are in that situation, the consequences are, if something were to happen to someone.
Yeah, absolutely. And regardless, for example, if somebody's driving through the street, let's say that the person driving is above the legal limit of 0.08 here in California, and somebody suddenly runs out in front of them in the middle of the street and they hit them. Are they still really looking at a felony DUI?
That's a good question. So it's a question of proximate cause. You still have to prove that the drinking and driving ultimately is what led to the person's death. And so you have a situation sometimes where if the person driving, if their intoxication had nothing to do with what happened to the other person, that's a defense, right? Now, still might be guilty of a misdemeanor DUI. But the problem is if you've got a dead body on the ground, the prosecutor and the cops are going to look at that case and they're going to think of a reason why. And they're going to say, well, because of your level of intoxication, you weren't paying attention properly. It slowed your motor responses. And had you not been drinking, you would have seen this person, you would have hit the brakes, So it does come up, sometimes you get, a friend of mine had a three-way car crash where everyone was drunk, you've had, you get situations where someone is driving properly and they get hit by someone someone's under the influence driving properly. They get hit by someone who's not under the influence, but then because they were under the influence, they go to jail. I've been told it's a byproduct of, for a long time, this was not really an offense that people considered to be that serious. Drinking and driving was just kind of something people did. I mean, speaking with my mom about her folks and my dad about his folks, it was like, if you were hammered driving home from a work event, you got pulled over, the officer would just take your keys and have you walk home, And so it wasn't really that big a deal. So we had this kind of like snap in the 80s and 90s where now you're at a point where, you can't, if you're a 0.08 or above, you're going to probably be on a probation. You're probably going to have to do an alcohol problem. You're probably going to have to pay some fines and fees. I think there's probably a more nuanced approach in there, to your point. But that's where it stands now. So, these are all great questions. It's a very common offense, and I think that if you're in law school, you've probably been to a few happy hours, that you might be worried about. So, it comes up quite a bit.
Yeah, in all kinds of professions, and again, it's holiday season's coming around, and so I think it's important that people know these things because, again, you and I both as lawyers get these calls from friends, colleagues, et cetera, right around this time and scattered throughout the year, but. Yeah. It happens far more frequently than people would think. And the vast majority of the time, they just didn't know or didn't think it was that big of a deal. And so it's a hard situation to face. So, and also understanding what the consequences are many times are not explained other than the typical things you hear about in terms of potential jail time, et cetera. But like what it really looks like. I think a lot of people don't realize that until it's too late. So switching gears, what about this idea of a police officer and the difference between them detaining you and arresting you? When can you leave?
That's a great question. Okay, so a detention is basically something short of a full-blown arrest. You think arrest, think handcuffs in a police car, going to the police station, fingerprints, booking photo, full-blown custody, right? Detention is an officer saying, hold on a minute, let me ask you some questions. And they're allowed to do that if they have what's called reasonable. It's actually lower than probable cause. Probable cause is, what it is, probable cause. So tier below that called reasonable suspicion. So It's like they see three people running away from the bank at the same time while the bank alarm is going off, right? Hey, guy, whoa, hold on. Wait here. What are you doing? What are you doing? They don't have to read you your Miranda rights in that situation. That would be a detention. So a detention is like, it's supposed to be a brief investigatory stop so the officer can assess what's going on and whether or not someone should be arrested or not. So they can detain you, ask you some questions, maybe ask some other people some questions. Maybe you're on the sidewalk. Sometimes maybe you're in the back of a car. Sometimes you're in handcuffs. But it's kind of a brief procedure where police officers are allowed to kind of sort out what's going on and then make a decision about whether or not someone needs to be arrested. And arrested is, like we talked about, full-blown. You're at the police station. You're in handcuffs. You're being read your Miranda rights. The legal distinction comes in primarily for Miranda. That's usually the primary distinction. And so, you're never under any obligation whatsoever to talk to the police. Like we talked about earlier, it's their job to investigate. You don't have to help them. I get the question, if you were to Google right now, should I talk to the police? You'll see a bunch of criminal defense attorneys' websites pop up, their ads. They'll say, don't talk to the cops, don't talk to the cops, don't talk to the cops. And that is, generally speaking, not a bad rule. But I will say that it's not always the rule. There are situations where it makes sense. And so, for example, I had a woman who was, she was dealing with a situation where she's being stalked, and she got into a fight with this guy, and she ended up getting arrested, right? They found a video of her hitting him or whatever the case may be. She got arrested. And normally the conventional wisdom would be like, don't talk to the cops, right? Don't have your lawyer reach out to them. Just wait and see what happens. But we were able to prove that this person we had like text messages, we had phone calls, we had videos, things like that we were able to essentially give to the police officer to help get the case kicked. So there are situations where it makes sense to talk to the police. Now it's a judgment call, right? It's not always, and it's risky, potentially. But sometimes, I've had clients, I'll go in and we'll walk in and give a statement, and as long as you sit down and talk to them, like, hey, listen, be honest with me, what happened? What are we looking at? And here's the risks of going and talking, and here are the risks of not talking. And then we make a decision. It's kind of case specific. And I know, I can think of one case in particular where a person I have a lot of respect for, he had a woman charged with attempted murder. She bailed out, and he took her to the police station the next day and just sat there while she talked for 3 hours to the police. And they ended up agreeing with her and dismissing the case. Now it's risky, right? But sometimes not talking is risky too. It's kind of it's a safe way for a lot of lawyers to avoid making it a tough call. But sometimes it makes sense to the police. And, I would say I would recommend, if you can, talk with a lawyer if you can before you make that decision. If you're in a tough spot and you don't know, it's better just to not talk and then come talk to a lawyer. But sometimes it can make sometimes it can make sense. I know your area of law too, Parag. I'm sure you have like the conventional wisdom about sometimes the way things should work, but that sometimes you kind of have to be a little bit more creative and think outside the box, and maybe you can get better results as a result of that.
Yeah, absolutely. 100%. In terms of some of the outcomes and some of the challenges, let's talk a little bit about concealed carry. That's big and continues to get more popular. LA County and California in general opened this up much more than it used to be in terms of how restrictive it used to be as far as who could get a concealed carry. And this is a question I get pretty frequently about, should I get a concealed carry, one, and then two, if I actually use my weapon here in California, because there's a lot of restrictions, including things like driving with a loaded weapon. And if they catch you with that being a felony, a lot of people don't realize that. Yeah. Can you talk a little bit about that? Like, one, what are your thoughts on concealed carry and the pros and cons, and give an analysis of how and when it might be okay to use a concealed carry versus not?
That's a great question. So look, to your point, I can't remember the name of the Supreme Court case, but it was a couple of years ago, where there used to be a lot of kind of arduous, prohibitive checks on people who wanted to get a concealed carry permit, such that it became almost impossible for certain people to get it. In California, before the Supreme Court ruling came down, you had to show you were the victim of like an ongoing threat, and you had to get it from you had to pass a background check, go to a police station, get approved by a chief of police, I believe it was. It's not an easy process. It was a lot of, active police officers used to be able to get them. Prosecutors used to be able to get them, or someone who's actively being stalked could be able to get them. Now the law changed, and the Supreme Court held that you can't really have these kind of hurdles that have been implemented by certain municipalities in order to get a concealed carry permit, and that it should be much more easy to get. So that being said, it's a very personal decision, and I, having worked at the DA's office for a long time, I have a lot of friends who are police officers and people in law enforcement, and a lot of them make the decision to conceal carry, and that's up to them. The laws are very specific. I think here in California, you have to be careful. You can't do anything around a school ground or in a bar or things like that. You got to be careful. You know what you're doing. And to your point too, if you're carrying in a car, you have to be very careful about where you put it, and it has to be secured in your trunk, unloaded, and all that kind of stuff. It's not a thing you just throw in your backseat of your car. And to your point too, a lot of these crimes are wobblers. The term wobbler we use in criminal law means that it can be charged either as a misdemeanor or a felony. So you could just be on your way to work one day, forget that you have put your gun in such and such place in your car, get pulled over for a traffic violation. The officer says, "Do you have anything in your car?" You're like, "Oh my God, I forgot about that. Yeah, I forgot I left the gun in my back seat," or whatever the case may be. And then, you get a prosecutor who looks at your case and decides it's worth a felony. And then all of a sudden you go from just going from on your way to work to having a felony. So my advice would be, talk with your gun dealer. If you have questions, you can call a lawyer, but be very careful about these situations, about where you carry, how you carry, and all that, because one little slip, can result in like the DUIs. One little slip can result in pretty serious consequences. I'm trying to think of situations where I've seen a concealed carry permit go sideways. You see a lot of crazy stuff in criminal law. I haven't really seen a whole lot of situations where someone who's responsibly handling their gun has gotten into trouble. Obviously you want to be very careful. And if you're in a situation where you have a gun in your car or on you, and you're having to answer some questions from a police officer, maybe one of the first things out of your mouth is, "Hey officer, just FYI, hands up," not like, "Here's my gun," hands up, I've got a gun on me, or hands up, I've got a gun in my trunk, things like that. It's a good question, Parag. It's obviously very kind of case specific. A lot of us who have our own firms sometimes have security concerns. We might keep certain things around just to be safe, but it's really kind of, I would say it's up to the individual. It's a good question. And I don't have a good answer other than be responsible.
Yeah, absolutely. And so can we talk a little bit more about what it means to be responsible? Meaning, here, I'll give you a hypothetical, and you give us the RJ take on whether you think this is a proper and lawful use or an unlawful use of a concealed carry weapon. So here in Los Angeles, there's a lot of homelessness. There can be significant pockets of crime. Let's say you've got your CCW, you're walking down the street, and somebody tries to rob you. Are you required to run or retreat from that situation? Or if you have a CCW, are you allowed to then pull it out and or use it?
That's a great question. So look, every situation is fact specific. So I can't really say any given hypothetical. I get these questions a lot, which is, what if someone breaks into my house? What am I going to do? Can I shoot them? What if it looks like they have a knife? What if it looks like they have a gun? So every situation is fact specific. So I can't say in any given situation how it's going to shake out. I will say this. As far as there are some states which require a duty to retreat, which is to say that if you're threatened with force or violence, there are some states that say if you have an opportunity to get away, you are legally required to take that opportunity. And if you don't, then you're potentially guilty of a crime too. So if there's a way, so a hypothetical would be like, you're 20 feet away from someone and you hear them yell at you. In about 10 seconds, I'm going to get out my knife and I'm going to come get it. It's a ridiculous hypothetical, right? I'm going to come get you and I'm going to get my knife. And those states, right, theoretically, you'd have to go walk away, jump in your car. You couldn't run at the guy and shoot him in the head, okay? You'd be in trouble. That's a ridiculous hypothetical. We got to illustrate what we're talking about here. Now, that duty of retreat does not exist in California. And it's a very fact-specific question. If someone pulls a gun at you and demands your wallet, what they're saying to you is, if you don't give me your wallet, I'm going to kill you. And you are entirely within your rights, generally speaking, to defend yourself against deadly force with deadly force. So a gun is deadly force. Someone pulling a knife on you is deadly force. With the implication is, give me what I want or I'm going to kill you. I'm going to hurt you really bad. And you are absolutely allowed to use deadly force in response to the threat of deadly force. Now, where it gets a little bit more tricky, someone breaks in, you see someone outside your window and they're breaking in, right? And they're not in yet. You pull out a gun and you shoot them. And look, if I was on your jury, you're fine. Okay? But at the end of the day, you're going to have some police officers and you're going to have some prosecutors who are going to be looking at your case and they're going to make a decision. The decision they're going to make is, did you really have to kill him? You know? And that's the view they're going to take. And then that's the argument you're going to have to deal with in court. So, it's a very fact-specific question. If you are being reasonable, you should be okay. You get situations sometimes. Where was it? I saw a video online of a guy who went in to go rob. It was like a restaurant. He brought in a gun, was pointing at the customers. And a guy who was concealed carrying pulled out a gun, shot the guy like 3 or 4 times. Guy hits the ground. And about 10 seconds go by, And he walks up to the guy, gives him one last round in the head. And you're like, you know what, man? You're probably going to you might not be guilty, but you're probably going to have to answer to that. So I could go on about this subject, but it's always, the problem is too, it's a very emotional situation. People react emotionally when they're scared for their life, and it's an understandable thing to maybe be sure that the person you're dealing with is not going to be a threat to you anymore. But to the extent that you can, you just gotta, it's important to be reasonable, and it's hard to say when you're faced with a life or death situation. Remember what this guy in this podcast said, but it's always going to be whether you're behaving reasonably or not, and whether you're behaving reasonably or not is going to be up to a jury, generally speaking.
Yeah, absolutely. And one thing I've heard regarding that is and I don't know if this is just an urban myth or urban legend, but you should shoot below the waist in there. That way you avoid an argument that you were trying to kill them, that you've got a better argument to say, look, I was just trying to protect myself. Do you agree with that? Or is that,
yeah, look,
is that silly?
It's a very, like I said, it's all very fact specific. So, if the police look at your case and they see it was hypothetically a person got shot, I can't remember the name of the artery that runs through the leg. That's a fatal artery if he gets hit. If he gets hit, it's certainly a situation they're going to be less inclined generally to arrest you than like the guy in the video who went up 10 seconds after the guy was down and shot him in the head. It's very, very, there's no bright line rule. It's not like if someone's in your house, you automatically get to kill them. And that you're going to have a good argument if that happens. You're going to have a good argument, but it's very fact specific. And that's how it's going to play out. It's going to be, how do the police officers view the evidence? And you want to get an attorney if you've ever in that situation. And then how the prosecutor views the evidence. It's, shooting below the waist is probably going to be a fact that's going to lead you to be less likely filed against than shooting them in the head. But everything is fact specific.
Yeah, 100%. So what if the fact pattern is you are an ex-hitman who just wants to retire, and then somebody comes and kills your dog, and that person is a part of a criminal enterprise? Are you allowed to avenge your dead dog by killing this criminal enterprise?
Well, so if you can kill the people like in a really cool way, like with pens and stuff like that, then I think you're totally off the hook. I don't think you got anything, and don't got anything to worry about. If you can kill them in spectacular fashion, then you got nothing to worry about.
Got to put on the show.
Yeah, absolutely.
Well, RJ, if people want to learn more about you or find you, call you for some help, how can they find you? What's your website? What are your social media handles?
Thanks, Parag. So it's it's Dreiling Law. That's D like David, REILING Law APC.com. You can find me on Instagram at Dreiling Law APC. I'm also under LinkedIn at Dreiling Law APC, and my name, RJ Dreiling. So the best places to get a hold of me.
RJ, this was super helpful. I very much appreciate you being on. I'm sure the listeners learned a tremendous amount, as I did, about the criminal justice system in general and some tips and tricks. So I very much appreciate you being on.
Thanks for having me, Parag. It was my pleasure. You're definitely a lawyer I have a lot of respect for. So thanks for having me on, and look forward to talking to you again in the future.
Yeah, I appreciate that. And to the listeners, thank you so much for joining. If you like this episode, make sure you like and subscribe so you know when future episodes are coming out.